What's up? It's your favorite attorney, y'all. Y'all already know how it goes. You write me, you say something, boop, it's on the show. So they wrote me and they said, if someone was already in jail on a current charge and while in there ended up being charged with another crime, should he have to go through probable cause court to be notified of the new charges? And is there a time frame for a person to go to probable cause on new charges? All right. Y'all, that's a good question. There's a few questions in one actually, but yes, any case that you're charged with, you are going to have probable cause. You have to go through that, okay? Unless you waive it, you do have a right in most states to waive probable cause. There are times where attorneys will waive it. Um, that needs to be done at the with the advice of your attorney. It's very rare that I waive it, but I have in certain instances. I will say that it's not necessarily a time frame but there is a time frame, because if somebody is holding you on charges where probable cause hasn't been found, in order to move forward, there needs to be probable cause found more than likely by some sort of entity. Okay. Sometimes the judge will not find probable cause, and the prosecutors will continue on with the case. And this has been the circumstance in some of my cases where the judges found no PC, no probable cause. The charges don't make sense, or something's erroneous about the charge in some way, shape, form, or fashion, and the judge decides, which is also rare, that no PC is found. The district attorney doesn't have to dismiss the charge. But I get a chance to run a probable cause hearing at that point, where now PC is going to be litigated. Okay, it's not going to be a regular, informal, quick PC hearing. Now it's going to be an adversarial hearing, where their witnesses, the ones that are dealing with probable cause, need to be brought, and I need to bring mine. And whenever I run this, and it's rare, it's so rare, I will subpoena the witnesses, because it's my burden if I'm requesting that hearing for my defendant. I have gotten cases dismissed like that. I will say one of the ones I just had recently that was like that was PC issues within it. It's still Safford. What is it? It's February. It says dismissed like that in the last month. So it's still sat for three months. You know? It wasn't quick. And I didn't challenge. I didn't worry about the time, because I just aligned myself to set up that hearing to move. And I would talk about why, but that's not something I really want to discuss. It's really an inside thing, and I'm not gonna do that. Don't worry, I won't do it to you DAs, but there is a reason why. And also, that's my secret. I'm not telling you my secret. But you can ask your lawyers, okay? Or, if you consult with one, you can ask that attorney, because it's a very intricate thing. But PC must be found, okay, sir, in order for cases to move forward. And then if it's a felony, the cases need to be stamped, indicted, run through a process where they stand muster, okay? Because there are screening processes to cases, and initially it's PC. Does it even sound like it could possibly be a case? You're not looking at the evidence really. You're just listening to what the state alleges, and saying with what the state alleges with what they allege, right? Does this make a crime? Is this a crime? Okay, so that's PC. So you run that. Okay, so when they're sitting there in front of the judge, right? Your lawyers can always tell you to be quiet, because it doesn't make sense really to argue in a PC hearing. If you're going to testify, your lawyer needs to prep you for that. It will be an adversarial round 2 hearing, and you would know that that's what you were getting ready to do, and you would be prepped and ready. So you gonna shut your mouth on the first go round. If it ain't adversarial, it hasn't been set, and people haven't been subpoenaed as witnesses, you're gonna hush. Okay, so when all of you all have come to that point and you're hushed, that's what that is. And the state reads the charges, and it's the first attack. It's the first way I can knock it out. Okay, because I'm aiming to dismiss the case. It's the first shot I have to knock it out. But it rests solely on the state's allegations and the pleadings as they are. And so it's limited. Okay, but PC does have to be found, guys. It's a lot, PC is not an easy topic. It's also an interchangeable topic as well. But yes, these were some good questions. But of course, the time frame would be no time frame. But come on, y'all. If it's the first time you get to knock something out, think about that. You're not going to be far along in the case to raise that PC. It has to be raised early on in the case. It must be raised early on in the case. If that makes sense. If you're going to challenge it, because it's addressed early on in the case. Okay? So I will say that. And then there are sometimes that people are, you're held before a magistrate. And the PC is done so that they can set the bond and move you along. So, I mean, I think PC has probably been found with this gentleman. There may be times where your court date, it takes a few months to get to your court date. But then there's a bond more than likely that's issued. It may not be fair, but... So it also depends on what county you're in. But the system runs how the system runs. And no matter how long it takes, it can't take that long, if that makes sense. I hate to say that, but the law is a living, breathing, moving animal, and each case is different, and I can't say with specificity, yes, this, yes, that. I can tell you the factors that go into making that decision. Right. Okay. So, bye. Without further ado, court is going to stand in recess. Y'all took me too damn deep. Ooh, Instagram ain't supposed to be this deep. I'm supposed to be slapping and lapping at 2 and 3 minutes. Ooh, that was a good one. Bye.